Hello, constitutional law students. This is a lecture from Module 6 about state governments in the U.S. Constitution. In this lecture, I'll attempt to explain two relatively complex concepts covered in Chapter 6 of your textbook, federal preemption and the Dormant Commerce Clause, a little additional discussion of a connected issue, which is state taxation. And then I'm also going to guide you to some of the most recent decisions of the U.S. Supreme Court relating to both of those concepts. And these are decisions that are not in your textbook, so you'll definitely want to pay attention to that section when I go over it in the lecture. Each of you are required to take Pols 101 as a prerequisite for this course. So you ought to recall the concepts of federalism and dual sovereignty. The two governments, federal and state, are both sovereign political entities established by their own constitutions. A few powers are held exclusively by one government or the other, but both governments can regulate commerce and both governments can tax. Those are shared powers or concurrent powers. Because the powers are concurrent, they sometimes conflict with one another. And when they do, the courts have to decide whether the state government's law can remain valid. And that's because of the Supremacy Clause here, which reads, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land." So you'll see that the Supremacy Clause is kind of the driving force for some of the constitutional law decisions relating to both federalism and dual sovereignty. But I'm going to start first with federal preemption. The word preempt, that word is, it sounds complicated, but all it really means is supersede. So to preempt means that, so if a law preempts another law, the first law supersedes the second law. Federal preemption means that a federal law will supersede a state law. So when a state law is preempted, it is invalid, and it cannot be enforced. Preemption is a consequence, then, of the concurrent powers of the federal and state governments and the Supremacy Clause. It's how those two principles of federalism and supremacy work together. Preemption does not happen often, but you do need to learn the analysis that the courts apply to the determination of federal preemption. So that's what we'll talk about next. When does preemption apply? For preemption to apply, you have to have two things. One, the federal law has to be validly enacted. It must be authorized by the Constitution. If it isn't authorized by the Constitution, then the federal law is invalid and can't be enforced. But let's assume that it is valid. So if the federal law is valid and authorized by the Constitution, then you go to the second point, which is whether the state law contradicts the federal law. So it's that two-step aspect for preemption to apply. First, the federal law must be validly enacted. It must be authorized by the Constitution. And two, the state law must contradict the federal law. Both of those have to be true for preemption to exist. So for this learning module, we're going to take that first part for granted. Take for granted that the federal law involved in the case you're reading is authorized by the U.S. Constitution. And we're going to just focus on the second part. Does the state law contradict federal law? That's what the cases are mostly about, is that second aspect of preemption. Always start out with the presumption that the state law is valid. We always begin with that presumption because state governments have plenary power. The U.S. Constitution defined and limited federal power and then reserved all other powers for the state governments. So state governments then have plenary power not the federal government. And that's the reason why we always start with the presumption that there is no preemption, that the state law is valid. So it's going to, federal preemption only really comes into play in very, very narrow circumstances. It does not happen often, but it is important, and that's why we're going to study it and pay close attention to it. There are three ways that your textbook has outlined for how courts are going to answer that second part of the question, whether the state law is valid. So, assuming the federal law is valid and authorized by the Constitution, how does the U.S. Supreme Court determine that the state law is contradictory and has to be struck down? So, it's one of three ways. The first one is express preemption. This occurs when a federal law expressly provides Congress's intent to preempt the state law. The law, in its express words, reflect that intent. So that you'll see Congress saying this law shall preempt state laws. But sometimes Congress's words are not very precise. They may be ambiguous in some respect. And then sometimes Congress includes a savings clause, so where they'll say we preempt some state laws, but not these others, or they'll say we aren't preempting at all. So Congress sometimes will express itself, will say its intent for us, and even though you would think, okay, if Congress says it, then that should be clear, right? There shouldn't be a problem. But there always is, or not always, a lot of times, there is some ambiguity that the federal courts have to resolve. And even the justices of the U.S. Supreme Court do not always agree on Congress's intent, even when Congress's intent is expressly stated. So you will see cases dealing with express preemption. Beyond express preemption, so the opposite of express is implied. So the other two would be considered implied preemption, but there's different analyses depending on what we're dealing with. Field preemption, that is implied. This occurs when Congress does not expressly assert its intent to preempt or to save state law. So when a dispute arises, the courts have to consider the big picture, the whole field of the law, and they have to ask whether Congress's efforts to regulate an activity is so broad and numerous that its intent is apparent, that it will exclusively regulate the activity. So they're implying or seeing an implied intent by Congress to regulate the whole field, the whole subject of the activity itself. And they'll find that even when Congress doesn't say so specifically, they're implying it because they're kind of looking at the big picture and really whether the activity is something we ought to have a uniform national regulatory scheme for. The other form of implied preemption is called conflict preemption. And this occurs when it's really in two areas. And you can see them outlined here on this chart. One instance of conflict preemption occurs when it is impossible, so impossibility, when it is impossible for a business to comply with both federal law and state law at the same time. It will also exist when the state law creates an obstacle to compliance with the federal law. So in either of those two instances, the state law is said to directly conflict with federal law. And so in that case, preemption would occur. But remember, for each of these three types of preemption, assume that the federal law will not preempt state law. So there is a presumption against preemption. The Supreme Court is reluctant to find preemption because the nature of the national government is limited, whereas the nature of the state government is plenary. the scale is going to tip in favor of allowing state governments their power and authority to regulate in the interest of the welfare of their citizens. And you should also note um, that preemption can apply even to common law. It's not just state statutes, laws that the legislature has enacted. It's also going to apply to common law decisions of a state court. You need to refresh your recollection on what those two types of law are. Statutory law, law enacted by a legislative body, and common law, which are rulings of the courts. So a judge deciding how to resolve a dispute, that resolution becomes a precedent for future decisions, and it forms the collection of those precedents form the common law. So the preemption analysis can be applied in either situation where you have a state statute or a decision of a state court, the common law. It'll apply either way. A good way to study federal preemption is given you in the textbook, where the textbook is comparing and contrasting two decisions about car manufacturers. And so I've created this table here to help you kind of do that compare and contrast analysis. I'm going to read through it in the lecture and then I'll come back and make some points about it. But both of these cases are, the excerpts from both of these cases are in your textbook. The first one is called, it's difficult to pronounce, maybe Geier, Geier, versus American Honda Motor Company. So I'm going to call that the Honda case. And then the second one is Williamson versus Mazda Motor of America Incorporated. And I'm going to call that the Mazda case. Okay. So the first one to be decided was the Honda case, decided in the year 2000. The facts are a car accident where the occupant of the car was injured in spite of the manufacturer's compliance with federal safety standards. There was a seatbelt in the car that the occupant was using, but there were no airbags. All right. So the manufacturer, Honda, had followed federal safety standards. They had the seatbelts provided, shoulder and lap, and the occupant was using it, but there was no airbag. And so the claimant, the person who was injured, filed a suit against Honda saying that Honda breached the standard of care because it didn't provide airbags. So this is a common law decision of a state court trying to hold Honda accountable for doing more than just complying with federal standards. The law at issue was the 1984 version of the federal safety standards that govern car manufacturing. And then it's being kind of counterimposed over state tort law. So this would be the common law judicial precedent on personal injury and design defects in motor vehicles. Okay, that's kind of the factual background of the Honda case and where what was going on that started the dispute. So the dispute becomes then whether, and this was something Honda argued, would those federal safety laws that it met, so it met the federal safety standard, whether that law supersedes or preempts a tort law decision. So could a jury and the judge have greater expectations than what the federal government requires of car manufacturers? So the issue is preemption. It becomes preemption, a potential conflict between federal law and state law, but we're dealing with state common law, a decision of a jury or judge. And then that in this particular case, the court said, yes, there is preemption that applies here. So let's explain the rationale then. What's the reasoning that the court used? So it looks at all three, well, really only two, it doesn't specifically mention field preemption. You don't see that in the excerpts anyway. Perhaps in the larger decision, we would see them discuss field preemption specifically. But just what you're responsible for is just noticing that they deal with express preemption and conflict preemption. So they're going to look at both of those types. With express preemption, remember we're looking for the actual words. What did Congress say when it wrote the law? And there is a statement in the federal safety standards in the 1984 law saying that it will preempt state law to the contrary. So you think, okay, open and shut case then, right? So it's clear Congress intended to preempt. But no, not that simple. The court recognized a couple of things. Number one, they're going to narrowly interpret that preemption statement. So they're not going to assume that the Congress meant more than what it actually wrote. And also, they noted that there was a savings clause in the statute. So clearly, Congress was not intending to preempt everything. So they have to go, okay, so maybe express preemption doesn't provide us a source because we're going to interpret it narrowly and we see evidence that they didn't intend to preempt everything. So now we've got to really look deeper and consider conflict preemption. And so they have to analyze now whether compliance would be impossible or whether compliance with the state law would be impossible. Could the car manufacturer comply with state law and comply with federal law? And then they're going to look at whether the state tort decision would become an obstacle to compliance with the federal law. And that's kind of where they rested. They found that conflict preemption did exist. And it's interesting, the way they did it was by looking at the commentary made by the Department of Transportation. So this is the agency of the government that makes these rules. That the people who wrote the rules stated that they weren't going to require airbags yet, that they wanted to wait before they started requiring airbags. They did not want car manufacturers to have to provide them yet. They're going to allow this sort of gradual introduction of airbags into cars. I'm sorry, it got cut off there just a little bit. A gradual introduction of airbags into the design and manufacture of cars. So that's the Honda case. Now compare that to the Mazda case. And there are a lot of similarities, a lot of them. It's also a car accident. In this case, the occupant died. So the people suing are the family of the decedent, the person who died. But they are suing the manufacturer of the car, in this case, Mazda. And they're saying that in spite of Mazda's compliance with federal safety standards, Mazda still is responsible for not having included a shoulder belt. They had installed a lap belt in this is the middle seat in the back row of the car. The poor person who gets squeezed in the middle there, they only get a lap belt. They didn't have a shoulder belt. And the family of the person who died said that's Mazda's fault. They should have included a shoulder belt. If they had, this person would not have died. So it's very similar. We're talking about restraint systems. We're talking about safety standards that Congress has issued rules on. And it's a challenge. The expectation of common law is higher than the expectation of the federal statute. So you're looking at a conflict between tort law and statutory law, federal statutory law. There is something of a different version. In the Honda case, it was a 1984 version. In the Mazda case, 11 years later, we're dealing with the 1989 version. But it's still pretty similar. I mean, we're talking about restraint systems in a vehicle. And the issue is exactly the same, preemption. because we've got a claimant trying to say that in spite of complying with federal safety standards, there's a higher standard of care that the manufacturer should have obeyed, and that higher standard is provided by state tort law. So you have a potential for a conflict between tort law, state tort law or common law, and federal statutory law. Normally, when cases are very similar to one another, the older case would serve as precedent for the newer case. So you would expect the Supreme Court in the Mazda case to look back at the Honda case and say, oh, well, we've already said that conflict preemption exists in this situation. Therefore, it must exist now. And so claim it, you lose. There is, yes, that your claim is preempted. You can't go forward. That might be the expectation. That's how precedent works. But in this particular situation, what you see is the U.S. Supreme Court distinguishing the Honda case. They find differences in the circumstances from the Honda case, and those differences mean that Honda's outcome does not control the Mazda outcome. So the Honda decision is not outcome determinative. We're going to go through the analysis again and look at some of the differences that exist in the Mazda case. So they look at express preemption. They kind of come up with the same analysis saying there is an express preemption statement in the federal law, but it is read narrowly, and there is a savings clause, so it isn't clear what Congress's intent is expressly. We don't see discussion of field preemption in the excerpts, but we do see them go on to conflict preemption and consider even where there is an express statement by Congress, that doesn't necessarily end the discussion. We will also look at conflict preemption. And they held in the Mazda case, no, there is no conflict preemption because we've got a different situation, different circumstances surrounding this law. In this case, the agency that made the rules had represented to the court that it was not, it did not intend to preempt common law. The lawyer who represented the DOT represented that to the court. So they made the statement, no, we didn't intend to preempt common law standards in this situation. We're really just letting car manufacturers make a cost-based decision, and consequences will be consequences. We aren't intentionally trying to allow a gradual introduction of the shoulder belt. We are just letting them make a cost-based choice. And because of that information that the court garnered from reading through the statements of the regulatory agency, the Department of Transportation, that difference was controlling. That was the reason why, okay, then there's no conflict preemption. You may proceed with your wrongful death claim against Mazda. So here we have both cases addressing the same car safety regulations and the potential conflict between those regulations and state common law. The court arrives at a different outcome. That is an example of the court distinguishing precedent so that it would not bind the outcome of a subsequent decision. Normally, a case that's so similar, the prior precedent would be outcome determinative. The older case, the Honda case, would be precedent for arriving at the same holding in the newer case, the Mazda case. But because of factual differences between the two cases, the older one did not determine the outcome of the newer one. The two cases were distinguishable. The newer case was considering a newer version of the regulations, and the intent of the regulatory agency for the newer version of the regulations was different. You can also see other legal principles here that I've kind of mentioned about preemption. Number one, there is a presumption against preemption. You should have noted how the court applies a narrow interpretation of the express preemption clause in the federal statute. They would not assume Congress meant more than it said. So it's a narrow interpretation. And that goes along with this presumption against preemption. The other thing you should see here is that preemption comes in more than one form. Even though there was an express statement in the law about preemption, the court did not stop its analysis just after considering express preemption. It went on and considered conflict preemption as well. So the court's going to look at all types of preemption. Third, preemption applies not just to state statutes, but also to state common law decisions. Both of these cases involve tort actions for personal injury. And then last, even when Congress includes a savings clause to preserve state authority to regulate a particular activity, the court can still find that conflict preemption is appropriate, and it will look to other sources of evidence for the federal government's intent. And in these cases, that other evidence were the statements made by the agency, the DOT, regarding what its intent would be for its regulation. Okay, that's all I have for express or for federal preemption. It is somewhat challenging to understand. So if you need to pause and rewind, back up, and listen to it again, you can, or you can always call or email me, and I can go over it some more. I'm going to move to the next topic, though, which is the Dormant Commerce Clause. You should remember the Commerce Clause from your Political Science 101 National Government class. It is a specific provision in the list of enumerated powers of Congress that reads, let's see, I got the quote here. Congress shall have the power to regulate commerce among the several states. And we've already studied several court cases that elaborate on the meaning of those words and the extent of Congress's power to enact laws based on its Commerce Clause authority. But, as is the case for most areas of constitutional law, the issue is more complicated than you might at first suspect. The court has concluded that the drafters of the Constitution had both a positive intent behind this clause and a negative intent behind this clause. The courts concluded that Congress intended, that the drafters of the Constitutional Convention or the drafters of the Constitution intended to give a positive authority. So the power to regulate commerce is vested in Congress. So that's the positive intent of the drafters of the Constitution. Congress can regulate interstate commerce. But the court says also the drafters of the Constitution had a negative intent. States cannot disrupt interstate commerce. So those are both of those elements exist in the grand scheme of constitutional law regarding interstate commerce. And we kind of have to look at how we've already looked at how that positive intent plays out when we were looking at Congress's, the extent of its power. Now we're looking at the negative intent. States cannot disrupt interstate commerce. And that is called the Dormant Commerce Clause, that negative intent behind the language of the Constitution. The power to regulate economic activity is a concurrent or shared power. It's not exclusive to either government. Both the federal and the state governments can enact laws that regulate economic activity. Because of certain limitations regarding economic activity, state laws can be held unconstitutional if in one or two situations. If the state law discriminates against out-of-state citizens, or if the state law imposes too much of a burden on interstate commerce. In either of those two situations, the Dormant Commerce Clause will require that the state law be invalidated or found unconstitutional. The principles apply in this situation even though Congress has not taken action. So that's we say Congress has not acted, therefore its power lies dormant. Okay, dormant like meaning asleep, hence the fun graphic I have on the slide. Congress has fallen asleep. So it is lying dormant. It has not acted. So only when Congress has not regulated an activity, only then will we look at the dormant Commerce Clause. If Congress had passed a law, then we'd be dealing with preemption. We'd be looking to see if the state law was preempted by federal law. But when there is no federal law, we can't deal with preemption. Instead, we deal with the analysis of dormant Commerce Clause. Okay? Um, so, um, even though dormant Commerce Clause may seem a little complicated at first, it's really not that it's really not that complicated. You have to think of sort of the broader principles behind this, and then it will make perfect sense for you. So here's some broader principles to think about. First of all, we're talking about discrimination. Okay, states cannot treat out-of-state businesses differently. They cannot discriminate. They cannot impose burdens on businesses from out of state that are not also imposed on their own in-state resident businesses. The only exception to that rule is for when states are acting as market participants. So if the state is a service provider, they can compete against other privately operated service providers from any state, even out of state. So if they're acting as a market participant, they are themselves a service provider. Okay, competition is all right. But when we're just talking about state laws, so the state's just acting as a government, they cannot discriminate against out-of-state residents. And that makes sense. You see anti-discrimination policies throughout the Constitution. Okay, another larger principle, states can regulate businesses in an effort to promote the general welfare of their citizens. Right? That's their plenary or police power. But in doing so, they cannot disrupt interstate commerce. Courts will balance the disruption or the burden on interstate commerce against the benefit that the state derives from its regulation. And that balancing act is very, very fact specific. It's very subjective. So you're going to see disagreement among the judges of the federal courts in the case law applying the principle. And a good example of that disagreement is you can see it in this case, and this is a really new case. It's called National Pork Producers Council versus Ross. It was decided just a couple years ago. And it's the very I believe it's the very um the excuse me, the most recent case involving the Dormant Commerce Clause. So that's the most up-to-date analysis of Dormant Commerce Clause that you'll get from the U.S. Supreme Court. And it's not in your textbook because your textbook was printed 10 years before it was decided. So I'm going to ask you to read a summary of the pork producer's case. I have it linked in this module. So you need to click on that link and go read the summary and learn about what the court is doing in this pork producer's case because it kind of looks like things may be starting to change. I don't know. It's a crazy decision. You've got, um, you know, different sort of groupings of the justices, kind of unexpected alliances among the justices, and it gets a little tricky. So that's why I'm not asking you to read the whole case. I'm asking you to just look at a summary that kind of lays it out in plain language. It's a lot easier to understand when you read from these summaries. So look at that and you'll get a sense of how our present court, the people sitting up there now, how they are looking at the Dormant Commerce Clause. Because it is starting to change. It's starting to change the way it hasn't officially changed yet. What you see in your textbook is still accurate. But you can kind of see that there's a tendency now to kind of change the analysis. Okay? Next, we'll talk about a specific type of law, state law, and that's tax law, state tax law. Okay. Um, it is the power to tax and spend is a concurrent or shared power. Although the federal government taxes income, state governments can tax income, sales, property, services. So the list goes on and on. State governments have a lot more authority to tax than the federal government does, but they both share that power, the power to tax. Um, so this issue of taxation or tax laws is intertwined with the Commerce Clause issues because you're, number one, you're talking about economic regulations, right? We're taxing businesses. So this taxation impacts commerce. So it's going to trigger analysis of the Commerce Clause. So it's not it is a concurrent power that both governments have, but it is not an unlimited power. So there are limits on a state's power to tax. There are limits on Congress's power to tax as well. But because it's a shared power, because tax laws impact commerce, this issue about taxation is intertwined with the Commerce Clause issues. And the court has come up with four criteria. This is another situation where you see the Supreme Court applying rubrics. And I discussed that with you in a prior module, the importance of rubrics and really looking at the specific words in the rubric. This is not a situation where you would paraphrase. Do not paraphrase a rubric of the U.S. Supreme Court. You got to use the words verbatim. So there's four of those, and they are listed in your textbook. I'm not going to restate them here in this lecture. I just want you to look at those on page 153 of your textbook and learn what those four rubrics are. Instead, I'm going to, instead in this module, what I'm going to do is just kind of help you understand why. Why do we have these criteria? And again, it's these underlying principles will make the criteria make sense in your brain. Once again, one of those principles is anti-discrimination. I mentioned this just a few minutes ago. This is underlying all of this analysis of the Commerce Clause, the Dormant Commerce Clause. We're dealing with an anti-discrimination theme. States ought not to discriminate against out-of-state businesses in their taxation laws. That non-discrimination principle is a running theme through the Constitution. You see it in the Privileges and Immunities Clause in Article 1. You'll see it in the 14th Amendment's Equal Protection Clause. So this is anti-discrimination is just an overriding principle of the Constitution. So it makes sense to have one of those criteria be anti-discrimination. States can't tax out-of-state residents differently than they tax their own residents. Okay? The next one is jurisdictional issues. We're not talking necessarily about courts now. We're talking about the jurisdiction of state governments overall. States have jurisdiction over their own citizens and residents. And then they have jurisdiction over individuals and businesses that have property or do business within their state if they operate within their state. So you've got citizenship, residency, owning a property, and operation of your business within a state. Any of those four things can give a state government jurisdiction to tax you. But states can't tax outside their own borders. So they can't just go and apply a tax law to other people who really have no connection with their own state. That's the reason why you have the criteria of substantial nexus. There must be a substantial nexus between the activity, the economic activity, and the taxing state. And it's similar to due process. So when we're talking about courts, courts don't have personal jurisdiction over a person or business unless that person or business has sufficient minimum contacts with the state. Likewise, a state legislature cannot tax a business unless that business has a substantial nexus with the state. And it's really it's a matter of basic fairness and state sovereignty. That's the reason for it. Um, the substantial nexus minimum context criteria has become slightly more complicated in recent years because of advances in technology. Um, and I'll get back to that in just a second. Let me mention one other thing before I do. Um, Everybody has to pay taxes, right? That's part of being a citizen is you have to pay taxes to your government. Tax money that you pay to your government is used by your government to provide services for its citizens, for you. So if you're a citizen, you're paying taxes to fund the very services that benefit you, okay? So basic fairness then, everybody's got to pay their fair share. If you're deriving a benefit from the government services, you got to help fund them. So paying your fair share of the taxes that pay for the benefits you receive, that is a basic fairness. And that's one of the principles behind this criteria. Okay, so all of these larger principles then are what motivated the court to identify these criteria, these rubrics. And I think understanding those principles or recognizing them will help you remember the criteria. Now back to that technology issue. That has become the sticking point of the most, like the modern U.S. Supreme Court decisions applying the criteria. And, it's that substantial nexus. All right, we're talking about that particular criteria, and we've got to blame the internet for this. It's become more complex because of the internet. In the past, before we had the internet, it was pretty easy to establish that a business had a substantial nexus with the state because you'd have a brick and mortar building. There'd be a physical structure in the state that evidences their contact with the state, their nexus. Right? They're obviously there deriving benefits from that state government because they are physically present. But now that we have the internet, businesses can operate in any state, in anywhere in the world, if they want to, without having a physical presence. They don't ever have to physically show up. All they do is engage in transactions, internet, electronic transactions. So what do you do with that? Can a state ever tax a business that's only operating over the internet? What do you do in that situation? And so there was a famous decision that's in your textbook, the Quill decision. It's on page 155 of your textbook. And in that case, the court said, we're still going to require some sort of physical presence before a state can tax a business. That business has to have a physical presence. If it doesn't, if it's just internet based, nope, they can't tax you. Okay, that was the law until 2018. So in 2018, we got a decision of the U.S. Supreme Court called South Dakota versus Wayfair. If you know anything about Wayfair, they are an internet-based home goods company. I've bought several things from Wayfair. It's slightly less expensive prices on home furnishings. And it's very popular nationwide. But again, they don't have brick and mortar buildings in every state in the U.S., but they do business in every state through the internet. So they have these transactions that go across state lines that are in many states around probably every state in the U.S. Wayfair is sending its goods to. But they don't have brick and mortar buildings in every state. They would just have them in some states. And South Dakota is one of those states where there is no Wayfair building. There's no structure. There's no distribution center or warehouse. In South Dakota, all they had were these internet transactions with people who lived in South Dakota. They were going online and buying stuff from Wayfair and it was being shipped to their homes. So South Dakota wanted to tax Wayfair just like it would tax any other business that was located in South Dakota. But Wayfair said, no, you can't. We don't have a substantial nexus. In South Dakota, we don't have a physical presence. So according to the Quill decision, you can't tax us. Well, the Supreme Court said, oh, yes, they can. We are changing the law. We overrule Quill versus North Dakota, and this other Bellas Hess decision that's on the books. We're overruling both of them. We're coming up with a new rule. And the rule is as long as your business does a substantial amount of, so a substantial, let's see, how would you phrase it? You get a substantial amount of your business income comes from your internet transactions with citizens of a state. Where that is true, the state can tax you. So, what I've done, because the Wayfair decision is not in your textbook, I've included a link in the module for you to read the syllabus of the Wayfair decision. The syllabus is enough to get to understand the decision. So, click the link, follow it. It'll take you to the whole decision, the whole long decision. But I'm only asking you to read the syllabus because I feel like that's enough for you to understand. So look at that, and it'll make more sense than I just did, trying to understand the reasons the court gave for overruling Quill and allowing South Dakota to tax Wayfair, even though Wayfair didn't have a physical presence in the state. Okay, now we're on to this update on some issues. Additional, I've given you already two updates. Here's a couple more. The chapter in your textbook talks about the application of federalism in the context of immigration laws. So this is a situation where Congress has acted. We're not dealing with dormant Commerce Clause. Congress has acted. It has passed many laws governing immigration. There is a specific power vested in Congress to regulate immigration, and so Congress has a broad regulatory scheme. There's a whole department in charge of immigration. So Congress has acted. We're not dealing with dormant Commerce Clause. Instead, we're dealing with federal preemption. And since the publication of your textbook, the U.S. Supreme Court has issued a couple of new decisions elaborating on federal preemption in the context of immigration. So I need you to read the summaries of those two new decisions, Arizona versus United States and Kansas versus Garcia. I've added links in the module for you to look at those summaries, and I need you to pay attention to them and learn the holding of those two cases. What did the court decide? That's what you're looking for. What did the court decide? Um, There are other provisions in the U.S. Constitution. We've just focused on commerce and taxes and then a little bit about immigration. But there are other parts of the U.S. Constitution that place limits on the powers of the state governments, and I don't want you to overlook those. Your textbook outlines them on pages 158 through 160, and I didn't see reason to add. It's pretty straightforward. I don't think you'll have trouble. Just read through them and become familiar with these other additional limitations on state power. Okay, that's all I have for the Module 6 lecture. As usual, you email me or call me, come see me if you would like some additional explanations.